Good evening. Welcome to everybody in the room and those of you joining us by live stream. We're meeting this evening on the country of the people of the Eastern Kulin Nation, who were the custodians of this place long before it was called Melbourne. We acknowledge with respect the elders and the communities of the Eastern Kulin Nation and their ongoing connection to country, and we warmly welcome any First Nations people who are here in Court 1 with us tonight, and those who are watching on the live stream. I'm Justice Melinda Richards from the Supreme Court of Victoria, and I'm here this evening to guide a conversation between two Chief Justices about current issues facing the courts. Courtroom 1 is nearly full, and the event is being live streamed. A recording of the event will be available for later viewing on the Federal Court's YouTube channel, and I think also on the Supreme Court's website. And I need to remind you that you're not permitted to make your own recordings of the event. We have a great deal to discuss this evening, and so I'm going to keep the introductions very brief. Chief Justice Debbie Mortimer was appointed Chief Justice of the Federal Court in April 2023, just over 2 years ago, having been a judge of this court since 2013. Before becoming a judge, Chief Justice Mortimer was a member of the Victorian Bar, practising in a wide range of areas including public law, human rights and environmental law. Chief Justice Richard Niall became Chief Justice of the Supreme Court of Victoria in February this year, so not very long ago. His Honour also had a long and interesting career at the Victorian Bar before being appointed Solicitor-General for Victoria in 2015 and then to the Victorian Court of Appeal in 2017. I have a series of questions that I'm going to work through this evening. There is a great deal to get through. I make no promises, but if we have time at the end, I will ask the audience for questions. It's not often I get to have a conversation with two Chief Justices at the same time, and so I may at times refer to them as Debbie and Richard rather than Chief Justice and Chief Justice. So, to begin, before we get into the challenges that courts are facing today, I want to ask you both to talk a little about the role of a modern court. Why do we have courts and what purpose do they serve? Debbie.
All right. Well, that in itself is a large question, but obviously we are here to resolve disputes that are brought to us. And we resolve the disputes as they are brought to us. We enforce the law where it needs to be enforced, having decided what the law is, and we decide what facts we're applying the law to. So courts are necessary in any democratic system to be able. They perform a governance function. It's a different governance function from the Parliament and from the Executive, but it's still a governance function, and they are just as important a branch of government as the other two branches, I would say.
Might be a bit ironic being asked what's it like being in a modern court when I work in a building that was opened in 1884 and hasn't changed much at all over those 170 years in structure. But I think the point can be made that a court is not a building, it's an institution. It's the judges that make up that court. And as an institution, us play a critical role in the relationship of government between the Parliament, the Executive and the courts. And I think that the court plays a pivotal role. Its function is really to underpin democracy, underpin prosperity and underpin security. And all of those three things are really important. You can't have a functioning democracy without a body that will determine where the boundaries lie. You can't have prosperity unless you have a court that determines disputes about property, about security of property, about engagement in the market, and you can't have security unless you have personal and property security. So the court plays a pivotal role, and I think Debbie made that point about a governance role. And that task of underpinning the rule of law hasn't changed in the life of the court. But as a modern court, it probably has to look to different ways of engaging with the community while doing and performing that same role. But basically, we're doing a very similar job that we've done over the last. We inherited them court systems from the United Kingdom. We've adopted and adapted it, but it's that's the critical role I see of the courts.
But that's the challenge, right? That the function hasn't changed very much, and it might not change much, but how we do it and the pressures that are brought on us as we're doing it, those are the things that are changing and changing really quickly. So that the adaptation that we have to engage in has to recognise that our function isn't changing that much, but the pressures on us and the changes that our communities are experiencing are changing really rapidly. That's quite a challenge for courts.
So you've both adverted to the role that courts play as an arm of government, and some of what we do, of course, is adjudicating on the lawfulness of executive action and less often on the validity of legislation. And to do that effectively, we need to be independent from the other arms of government, from the executive and from Parliament. What does judicial independence look like in practice?
I can start. It has a sort of personal and institutional component. Institutionally, independence arises from a number of sort of structures that we have within the court system. So appointments, tenure, maintenance of conditions of appointment, so that judges are not there at the wish or the bequest of or at the direction of the government of the day. And personally, it's got a lot to do with integrity, making the right decisions independently on the law and independently of direction or control or influence. What it looks like in practice is that we have to be independent, we have to be impartial, and there's a high degree of detachment, which means that it does separate us a bit from the day-to-day maelstroms of life. And one of the bad sides of that is that we can appear to be isolated or appear to be disengaged with the community that we live and work in.
I think that concept of there being a structural side to independence means that then sometimes, and you'll see this in the press and sometimes in the way we talk about a collective, we talk about the court as a collective, but really, and that's necessary because you are talking about an institution, but then at the same time, you're talking about individuals who are the people that exercise the power. And that's where, the oath that every judge takes is so important. And that's where it's not that there's a conflict in the roles of independence between the court and individual judges, but you have to people need to appreciate, the community needs to appreciate that ultimately it's an individual who exercises power. They're doing so as part of an institution. And there's independence at that institutional level, but there's also, it's extremely important to understand that there's independence at that personal level.
And it goes back to who appears in court, what are the parties in court. And often in this court, federal court, and in the Supreme Court, a government will be a party to litigation or have a direct interest. And we see that particularly in relation to judicial review of executive action or assessments of the validity of legislation. So the ability of the court to determine those questions and to have that determination accepted by the community depends on it being separate from the government. That is, people can have confidence that a court and a judge decided the case on the basis of the law, not because of the association or debt that they owe to the government or to the executive. And it's the same in criminal law. The state sometimes described as having a monopoly on legitimate violence, and the state has massive power, massive authority over individuals, over corporations, over the life that we live. But there are boundaries to that power, and someone or some entity has to determine where those boundaries lie. And if it's to be effective, that decision-making body in our structure, government structure, it's the courts, have to be independent and impartial from the people we're adjudicating in relation to, the parties who are there.
Just to be a little contrarian about it, does judicial independence just mean that judges are not accountable? I've heard it said.
Well, I think it's an interesting word, accountable, isn't it? Because it really it lies in the eyes of the beholder about what they mean when they say accountable. And I think in our community, as in many communities around the world, sometimes that word accountable is just directly equated with being elected, and that's the only concept that many members of the community might think about when they think about accountability. And that's, I think, perhaps why it can be said sometimes, oh, well, judges are not accountable. So there's an educative piece to be undertaken, I think, about understanding that accountability comes in lots of different ways. Ministers are accountable in Parliament for what they do. Judges are accountable because we perform our function in public and because we give reasons for our exercise of power, and everybody can scrutinise those reasons. We are accountable because we sit in an appellate system. There are those sorts of things, but I do think that we need to broaden what we mean when we talk about accountable.
Yeah, I think accountability is often a synonym for popular, in the sense that people feel that if you make an unpopular decision or something which goes against the sort of prevailing sentiment, that's an unaccountable decision. That is because you're not accounting to the popular will. And I think that's why it's so important when one looks about accountability that there's conceptual clarity about what courts do and how they're valued and how they're assessed and how they perform their tasks. And if accountability means that the public should expect courts to make the decisions that they want, the outcomes that they want, then I think that misunderstands the judicial process. It misunderstands the role that we're playing. But at the same time, as Debbie said, we're accountable in the sense that all our work is done, unlike the other branches of government in many ways, although Parliament sits in open, but all our work is done in open court. All our decision making and all the argument and all the debate occurs in open court. We publish reasons for our decision, which are publicly accessible, and there's an accountability through the appeal mechanism. So I think there's a very high degree of accountability by judges. It's very, if you make a decision, you can't just bury it. You can't just close the court because you think it'll be an unpopular decision. It would be better if people didn't think that I'd made that decision. So I think judges are very accountable.
Does judicial independence also require a degree of restraint from judges, given that it's our role to, if you like, patrol the boundary of lawful action? Are there areas that we shouldn't enter into?
You mean restraint in terms of how the way we exercise our powers?
Yeah, the way we exercise.
I'm just questioning the questioner just to make sure I understand the question.
Yes.
Right.
and any commentary that we may add to the decisions that we make.
But yes, because the kinds of things that Richard talked about in one of his earlier answers about, and that I think as we've been preparing for this, the three of us have been talking about that our system, our governance system, and particularly the way that where courts fit into it, it's really quite fragile. And if there isn't a high level of respect and restraint in the sense of dealing only with what we need to deal with and dealing with it respectfully and fairly, then courts risk losing their legitimacy, I think, in the eyes of the community. And we don't talk enough about how important legitimacy is. Another expression is, community confidence. If we don't, in the way that we go about our work, behave in a way that will enhance confidence and enhance legitimacy, then we risk losing that, and restraint is part of that.
Yeah, I agree with that. I mean, I think there's a real role for judicial humility in the sense of understanding the role the court plays. So I think each of the branches of government, when we're dealing with review of governmental decision-making, for example, each of the branches have to respect the role and the different role performed by the other. And it's when we talk about the rule of law, I don't think that is the sole responsibility of the courts. It's a joint responsibility. It's a joint obligation of all of the branches of government to perform their roles within the constraints that operate, and together harmoniously underpins the rule of law. And what that means is, in relation to judicial review, we've often talked about the distinction between the merits of the decision and the lawfulness of the decision, and it bedevils a lot of practitioners as to where that line is. But fundamentally, it's a really important point. And when we overstep that mark, it risks changing the nature of our decision making. It risks really misunderstanding the limits of our role to declare and enforce the law, rather than make decisions as to how the state should be, by state, not state, but the broader political entity should be managed and should be run in that respect. But at the same time, we don't have a theory of deference. That is, we don't defer to the views of the executive or the parliament as to what the law is. That's our role, and we have to be very affirmative in that task. So there's no restraint in that process. And I think one of the other areas of legitimate restraint is, because we are impartial and have to be seen to be impartial and detached, I think that operates to preclude judges being engaged in matters of public controversy, or areas which sort of elevate the individual judge rather than the institution of the court. It's not when we've got individual responsibilities and we make individual decisions, but it's not about an individual judge. It's about the system of which we form a part. So that's another form of restraint outside of the sort of courtroom. That, we don't.
Or sometimes inside the courtroom.
Yeah, sometimes inside the courtroom. So we don't associate, or shouldn't, I think, associate ourselves with controversial views, public views, for example, because that does undermine the ability of the institution to discharge its obligations faithfully, independently and impartially.
Can I go back to something that Richard said about judicial review and about the limits on what the judicial function is with that? Because I think a matter on which many judges might differ is what you do in that sort of situation where you've got a case that's about the lawful limits of power, and you've decided that, and yet the case reveals an obvious injustice to the person concerned. And I think if I reflect on our court's jurisdiction, you know, we deal with the NDIS scheme, we deal with asylum seekers, we deal with social security recipients, we deal with lots of vulnerable members of the community. And the absolute reality is that at the executive or administrative level, sometimes there are injustices. And so what should a judge do when you are faced with a case where your conclusion is that the exercise of power is lawful and you're not in any doubt about that, and yet there's an obvious injustice either in the policy that's been applied to the person or the failure to really grapple with their circumstances? And should you, somewhere in your judgment, point that out or not? And I think that's a matter that lots of my colleagues have different views on. But that really comes back again to what I was saying about you take an oath. Personally, you adhere to that oath. We won't all think about that oath in precisely the same way. And so long as we remain conscious of the difference in our function from the executive or the administrative function, I mean, my personal view is that judges should reflect carefully and not do it very often, but sometimes you might want to call out an injustice, if for no other reason than to draw it to the attention of the executive, and then say, whether you do anything about it is up to you, but I'm not going to sit through the evidence that I've sat through and the circumstances that I've observed without making it clear that I recognise that there is. I don't know what Richard thinks about that.
I'm not so sure.
We want a bit of
Well, I sort of I mean, I think two of the issues that I think about is, one is when we say things, it carries a lot of authority, and secondly, I think sometimes what appears to be injustice is a product of decisions made about competing priorities and interests, which are not really for us to decide. And I think sometimes there's a risk to be saying, well, it's associated with a particular outcome or a particular priority. So I think it's a matter to be cautious about, as you rightly said, Debbie. You know, and sometimes it's inevitable that you expose in the course of your reasons things which seem plainly unfair and unjust, but which don't necessarily amount to unlawful decision making.
Yeah, and sometimes the exposition is enough, and maybe you don't need to add a comment. But I remain open to the possibility that sometimes you do.
So I want to
well, actually, that's quite a good, interesting point.
Make my job hard.
Because one of the things, and we might come to it as a head of jurisdiction, is recognising that each judge has their own responsibility to decide the case and give her or his reasons for it. And that is that personal duty side of it. And it's difficult for, you know, a head of jurisdiction to say anything. You know, you can't really have policies about that. And often, you know, people will say, well, you know, a judgment which might be controversial about a topic, and they say, well, why can't the Chief Justice go and talk to that judge and make sure that doesn't happen again? And then that's again another sort of complexity about the courts that are not easy to explain to people in the community.
So these are challenges for individual judges, and I think you've identified a challenge for a head of jurisdiction. But just before we leave the topic of judicial independence, are there any current challenges to judicial independence in our system of government?
Here or overseas?
Well, you can talk about overseas to begin with.
Away you go, Richard.
Oh. Look, I think there are challenges, definite challenges to independence of the courts, because, as I said at the beginning, I see a court as an institution, and not just overseas, but in Australia, institutions are under challenge, and institutions are rightly under challenge, I think. We can think of many institutions that have been held you seem to be as fundamentally important to the society, which we now recognise are not. I mean, the institution of marriage, for example, has fundamentally changed for a lot of people. There are other institutions which constantly need to be challenged. So, and courts shouldn't be afraid of being challenged as an institution. But some of the attacks on institutions are so fundamental and so destructive that they're not constructive with a view to improving the institution, but they're about knocking it over completely. And I think that's a challenge that we as courts, the authority of the courts to make decisions to decide cases is under challenge, because it's an institution of government which is one of many institutions that are under challenge. So that's a sort of societal distrust of public service, or societal distrust of government, that is inevitably going to affect courts and judges, and we see it in a variety of ways. I think perhaps social media presents some challenges for independence, in the sense, again, of the pressures on individual judges to hold strong to their oath when they see just the constant barrage and uninformed debate. But as an institution, we can't say, well, all that debate's just uninformed and we're not going to engage with it. And one of the difficulties is sort of that level of engagement that I talked about. But yeah, certainly that institutionally there's a risk. I think governments, and it's not new, but governments like to be in control. And I think they don't always deal well with alternative repositories of power. And courts are definitely a repository of significant power. And so there's a lot of pressure on them that governments can, I think, both here and overseas. And then also the third one, I think, is fiscal challenges. I think if the money is not sufficient to enable the court to operate appropriately and discharge its responsibilities, then I think that also has issues for the independence.
Yeah,
independency.
I would agree, especially about that last one. I mean, I think we can talk a lot about values, about judicial independence, and about, but that means that judges in every single level of the judicial system have to have a reasonable level of resourcing and support, and guaranteed resourcing and support, to be able to do their jobs. And we don't think that is a controversial proposition in other areas of community life, and it should not be a controversial proposition for the courts. And I think when individual judges, or collectively when judges on a court, feel that they are under-resourced to an unreasonable extent, or their workload is unreasonable, those are the kinds of things that can start eating away at your sense of independence, and that's a bad thing.
Now I want to ask you some questions about expectations and measuring performance against expectations of courts. Just briefly, what can the community and government reasonably expect courts to do?
I think it's reasonable for the community. Well, they're a little bit different, aren't they? What the community can reasonably expect and what government can reasonably expect. So I think taking the community can reasonably expect that judges work hard and that we work as efficiently as we can, and that we look to run our courts as efficiently as we can. The community can expect that we are fair in how we deal with the litigants that come before us, but sometimes there's a big gap in the perception of individuals who come before us or the community about what is fair. And I think that perhaps we don't talk enough in an open way with members of the community, particularly outside the legal profession, about what is fair and the way that resourcing challenges and workloads and the need to get through all the litigants that are waiting to come into our system affect what is fair. So I think the community can reasonably expect they can reasonably expect us to be impartial. But again, we don't have enough conversations about what that means to be impartial. And it doesn't mean that you're some sort of automaton that comes with no life experience and no views about anything. And so those are all reasonable expectations, but they're only reasonable expectations if there's an understanding about what those concepts mean, I think.
And I certainly think that the community and governments can reasonably expect that courts will be accessible. That is, that it's possible for people to go to court. Now, our end of it, we have responsibility for that to some level, but also there are other things that are pose challenges for accessibility to courts that are outside of our control. I think the costs of court proceeding are really a massive factor, obviously, in accessibility. And the courts have some, but by no means all of the responsibility or control over that aspect. We might return to that. I agree with Debbie that they can reasonably expect diligence and integrity on the part of judges and that they'll apply the law, but they can't reasonably expect a particular outcome in a case. I think you read articles that they say, well, how possibly could a judge have come to that conclusion? You know, as if the expectation is that they must have come to the opposite conclusion. And I think part of that is we haven't explained sometimes the complexity of the issues that confront us. If we could only hear from one side, our task would be a lot easier. The outcome would be a lot more obvious, and everyone would think, well, obviously that's the right decision. But as part of our system is we hear from the other side, and they always give a lot of reasons, or sometimes, often, give a lot of reasons why a different conclusion should be met. So that expectation of outcome is really difficult to explain. We've got to do our best to explain our outcomes, but I don't think they can have a reasonable expectation of a particular outcome in a particular case, having regard to the complexity of the law and the competing interests and the balancing interests, because we're often balancing a whole range of things, for example, in sentencing, in relation to bail decisions, all of those decisions which are often can be controversial. The court's called upon by the law to apply a whole range of factors, often pulling in different directions. And so that adds a degree of complexity to the.
So that's something about the expectations. How is the performance of courts against those expectations measured? Are there any reliable performance measures that can be applied? And I'm just leaving aside the appellate process, the performance of courts as an institution.
Well, I would come back to that intangible proposition about do we feel that the community has confidence in what we do?
How do we know?
Well, how do we know? I think we can look at whether, by and large, people respect the orders that are made, or if not, they abide the enforcement of the orders that they don't respect. I think we should look at, and again, I think because of social media, because of the means by which we communicate with each other these days, sometimes I think we get a skewed understanding of how confident the community is in what we do.
Because you read the comments.
Well, I don't read the comments, but the comments are reported. And so I do read the newspapers or the digital versions of the newspapers. I think it's hard to measure performance. I mean, we do, courts publish annual reports. Courts do report back on what our workload has been in a year, how we've discharged it, what the challenges are. We do try and engage in a sort of reporting mechanism, and I don't know if anybody reads them, and it's maybe, again, we're not accessible enough about how we produce those sorts of documents. They could be really important documents, should be.
I think one of the things since taking on this job I've been thinking about is how you do measure a court's performance. And it's a really difficult task because you can't just look at the number of initiations in a period of time and the number of finalisations in a period of time, which is two very common metrics that are applied in relation to courts, because there are a whole range of issues in there that might impact on that, the complexity of the case, the type of case. We could get very high initiations in a very large number of undefended winding up applications, for example, which might be dealt with very quickly. But then we also might have a very large number of institutional abuse cases, which might take a long time. Both they're complicated to prepare by the lawyers, they're complicated to hear at trial, and they're complicated to decide. The facts are often historic. There might be a lack of witnesses, or there may be very many witnesses, and there may be very complex issues of liability and damage. So those things can take a long period of time. So how do you measure, is the court doing a good job or a bad job, simply on the throughput? But you do have to keep an eye on throughput. And then it's difficult to measure other aspects of the judicial process. So I don't know that we've got the right metric, which is difficult because we live in a world where data seems to dominate, and people want to know performance by, it's not valued if you can't measure it. And courts are incredibly difficult to measure, I think. But at the same time, I'm sure that both Debbie and I acknowledge that the courts that we work in are public institutions. They use public money, and we've got to be accountable and for those resources, that they're used efficiently and in the best way possible.
And I think that, certainly speaking about the federal court, I would be the first to acknowledge that there could be a discrepancy or a dissonance between perceptions of where a court like the federal court puts its resources and puts its judicial energy, because we do a lot of complex commercial litigation where there's a lot of money at stake, and parties are well resourced and well armed, and sometimes those are the cases that seem to go the longest, to occupy the judges the most, and that can make us look like we're catering to a privileged section of the community, possibly at the expense of other sections of the community. And I mean, Richard's touched on this about the issue of costs, and I think that is something that we do have to confront more, and that our court has to confront the nature and extent of judicial resources that are employed while we are operating under an adversarial system. And to this point, we've been very accommodating of parties, particularly well-resourced parties, about how much judicial time they can take up. And maybe that's something that needs to be reviewed if we're to develop confidence in our community that we pay the same level of attention to people that aren't as well resourced but whose disputes might be just as important to them.
So that's a facet of access to courts being a finite resource. There are only so many judges and we only have so many court hours and only so much decision-making capacity. So what can courts do to ensure that the resource of access to what we do is distributed fairly, where and when it's needed most?
Well, I think we have to have better and more active engagement with those who use the courts. And again, coming back to the federal court, I mean, this is a court where we get a lot of litigation from regulators, and the way that regulators conceive of and design their cases that they bring to the court affects, in large part, the proportion of resources, judicial resources and other resources within the court that have to be devoted to them. And I think it is time for a conversation about including in regulator cases where regulators might identify 100 contraventions. Do they need to identify that many contraventions in order to get the kinds of penalties or the orders they seek? Do we start having to front load constraints on parties, not just regulators, but private parties as well, about how much court time they can occupy, how they plead their cases, how they prove their cases? All those things are at the start of a judicial process, and unless you've got good constraints around those, you're never going to increase the capacity of judges to write more quickly or deal with disputes more quickly. There's a direct relationship between the inputs in terms of what comes into a trial and what a judge has to deal with at the end.
And it's not easy for us to say, well, we want 10 more judges tomorrow. That just doesn't...
It's easy to say, but...
Well, it's easy to say, yeah. So we don't have, in many ways, we don't have control over the number of judges that we have at any particular point in time. We don't have control over the number of cases that get initiated at any point in time. We can't choose those cases that we want to hear and those cases that we don't want to hear. We can't choose to say, well, these cases aren't interesting or we don't think they're that important, so we just won't accept them for filing. We have to deal with those constraints, and the obligation and the challenge is to make the systems as efficient as possible to ensure that the court resource is best used to most efficiently get through the cases that are decided in a fair way. We're also constrained in some ways by the judicial process itself, which has some defining and minimal features. It would be a lot quicker if we didn't have to hear from both sides. But we do, because the judicial process is not just about a legal answer. It's not even just about the correct legal answer, but it's also about the judicial process of procedural fairness, of being heard in open court and giving reasons. All of those things take time.
So, Debbie, you mentioned the phenomenon of the large, complex piece of litigation with top-shelf lawyers and money no object that can take up years of an individual judge's time. At the other end of the spectrum, there's a cohort of self-represented litigants who can be really challenging both in their behaviour and in the arguments that they raise, and soak up an extraordinary amount of judge time dealing with complex arguments that at the end of the day lack merit. My impression that is a phenomenon that's really spiked since the pandemic. And I wonder if either of you have insights into whether that is the case and any ideas about how we can meet the challenge that I'm sure all of your judges are talking to you about.
Well, I said before, the courts have to be accessible, and I think lawyers perform an essential and invaluable job, but they're expensive, and we're going to get continuing to get large numbers of people representing themselves for a variety of reasons. And in a variety of circumstances. Some of them, I think, a small proportion, are sort of motivated by sort of an institutional challenge type approach, but that's a small, very small cohort, but they can occupy a lot of court time. And then there's just a lot of people doing their best to represent themselves in a very difficult context. And we look at that across in Victoria, across VCAT, the Magistrates Court, the County Court and the Supreme Court. I think there's a very strong argument that efficiency would dictate more provision of publicly funded lawyers, which would actually be more efficient, better access to justice and get better results. But we've tended to see more restrictions on publicly funded lawyers, particularly for civil litigation, where most of the self-represented litigants are. So that's a challenge for us. It's a challenge for government. But government and the Parliament have an interest in ensuring access to the courts and an efficient court system.
I agree about the potential equation or evaluation of where the cost benefit lies with litigants in person in terms of the amount of resources they take up for government to defend litigation brought by them, as opposed to the funding of more publicly available legal representation. I would really like to see how those numbers stack up, because my hunch is that you could provide a cost-effective and widely available public legal system more cheaply than you could continue to defend all the litigation that is brought by people in person. And I don't know if there is anybody in the Academy that is doing that kind of research. I would really like to see it, because I agree, Melinda, that since the pandemic there has been an increase. And I think, ironically, part of the explanation for the increase in people representing themselves is that we are becoming more accessible. And we in our court, we continue to have remote hearing as an option. All our files are digital. We are becoming more accessible, and I think the tendency from at least a cohort of litigants in person is to think, we don't need a lawyer. I can do this. It's no different to when I deal with Centrelink, which I also do over the computer, and I can deal with Centrelink in that way, and I can fill out forms and I can make my arguments, and therefore I can also deal with the court. And again, maybe we need to work harder at helping people who wish to represent themselves or have to represent themselves to understand what's involved in doing that, putting some reasonable boundaries around their behaviour and consequences if they don't meet that behaviour standard, putting some reasonable boundaries around how much of our judicial resources they can consume, but explaining that to them at the start and consistently, so that you're able to then legitimately impose consequences if people don't abide by the standards that you've told them since they started their litigation they need to abide by. But that again requires a lot of new kinds of resourcing of the courts, because that doesn't just, there's no judges, registrars or registry staff sitting around twiddling their thumbs able to suddenly stand up and start providing all this support to litigants in person. my personal view is there's lots that could be done in that space, but government needs the will to allow us to do that, and then they need to provide us with the funding to do it. But we could do that.
Turning from litigants in person to the profession, do practitioners have a role in making sure that the cost and complexity of litigation is proportionate to what's at stake?
Yes.
Yes. Next question.
How do we hold them to that is the more difficult question.
Practitioners are in a difficult position, aren't they? Because they're running businesses and they want to make a profit on the one hand. On the other hand, they're officers of the court and they have to assist the court to discharge our work as efficiently as possible. And those two responsibilities are not always entirely compatible. But we all know which one prevails, and I think we need to talk a bit more about that.
Well, we've got the Civil Procedure Act in Victoria, and I think that has a positive effect in a number of ways. I think generally, more than generally, the expectation of the courts, which is met, is that practitioners responsibly prosecute litigation. But it's complex and it can be time consuming. So it's difficult to get the balance right. And, Debbie talked a bit about case management changes and structures that change, but they're all always coming back to some difficult issues, which is the complexity of litigation and the need to deal with large amounts of information in an efficient way.
I also think that the courts can help practitioners deal with the expectations of their clients a bit more than we do. And this is not a big picture issue, but it's an important issue. We've seen that both in Victoria and more latterly in our court. We're playing catch up with the Victorian courts about this, with the practice notes about junior counsel and speaking roles. Now that's something that we know from the profession can be a very difficult conversation for practitioners to have with their clients who have paid vast amounts of money for a senior counsel to stand up. And now the practitioner is saying, well, actually, how about we let the junior do this? But the educative effect that's been, I think, witnessed and is a tangible effect about the court saying, this is what we expect, this is what we would like to encourage, gives practitioners something to go back to their clients and say, well, actually, this is coming from the court, it's not coming from us. There's structural reasons why allowing junior counsel to make arguments are important to the development of the independent bar and therefore to the quality of representation. And maybe that's a kind of approach that we can expand more to deal with some of these other challenges about, really the large amounts of time and cost that litigation takes up. I don't know, but I think it's worth a try.
Now, time has flown and we have a lot more we could cover, but less than 5 minutes
say
left.
a couple before we go there? We've talked about a lot of challenges. I'm very optimistic about the courts, and I think both my experience and Debbie's experience is that judges who come to court, that is, who join the court, are incredibly conscientious and incredibly respectful. That's been my experience on the court, and I'm sure it's Debbie's experience on the federal court, both as a judge and now as Chief Justice. And each of them approach it in different ways. Not everyone approaches it in exactly the same way, and that's a plus of the system. But I think the judges work incredibly hard, and they are incredibly conscientious and responsible. So some of these problems seem like we've been talking about a lot of problems, and some of them are perhaps intractable, but they certainly don't the court doesn't come at them as if they're intractable, and certainly my court constantly looking at ways to improve, do better, be more efficient. And when I attend divisional meetings, I'm struck by the positive attitude of the judges to try and improve, and the concerns they have when there are delays. I really never hear complaints about the burden that it is. Much more do I hear the observation of the burden on the parties or the burden on the community. And I'm sure Debbie's experience is exactly the same.
Yes, so we shouldn't underestimate the optimism that we should have. And we haven't actually talked about overseas situations, but can I just say we should never do anything other than be grateful for the systems that we have here and the respect that exists between branches of government, and we should never take that for granted. And just look across the Pacific and you can see what happens when that respect breaks down. So, we have lots of cause for optimism in this country, I think, about our judicial system.
Are you optimistic enough to take one or two questions?
Yes.
I think so.
Mandy.
Just picking up Debbie's last point, I wanted to circle back to which includes courts, and I think that's my question is, as a challenge facing our courts, do you think there is more that can be done than or others to better inform the community
Well, that goes back to something I said at the start about our functions not having changed very much, but the way we perform them and the way we have to engage having changed a whole lot. So individual courts and judges moving from being quite isolated with engaging with the rest of the community, including through the media, and moving into explaining, engaging, putting ourselves out there. I think that is something that we have to do more than we do. It's not comfortable. We need a responsible fourth estate to work with us constructively if they really want to help us engage with the community and explain what we do. And we have to do our part to help the media engage in that way, but the media also have a responsibility to work constructively with the courts. If they're only one of the conduits these days. They're not the only conduit. But I think, and it's not a comfortable space for judges. We're not used to being in that space.
I agree with that.
Okay. Any other questions in the moments we have left? Not? Yes?
Well, we in the Supreme Court, we live stream a lot of cases. All the appeals are live streamed, with some exceptions. A lot of the trial division cases are live streamed. Some areas of law of our work are very difficult to open up the files. Criminal cases, institutional abuse cases are a good example, where I think there's good reason for caution in some ways to the dissemination of some of that information just into the community. Recording of court hearings for future viewing. I mean, I don't have a particularly strong view either way about it. But I think it's changed a lot.
I think in our court it's fair to say that the live streaming of trials is much more, it's subject to a lot more differences of opinion amongst judges than the live streaming of appeals. And our court works hard to provide online files where a judge considers it's appropriate and the parties either don't object or, having objected, there's been a ruling about it. And that's all, they are important components of accessibility, and they allow the community to observe things directly as if they were in court, and that is a good thing. What we don't know, again, coming back to the absence of research about things, what we don't know is what are all the consequences of live streaming trials. We don't know what the consequences are for witnesses. We don't know what the consequences are for parties. A lot of that is not visible, and it's certainly not being researched yet. And so my approach with that sort of thing is that we should be cautious, because you can't unscramble the egg once it's done. So I would like to see, again, I would like to see the Academy doing a lot of research about this. What do people think who've been witnesses and their evidence has been live streamed? Has it been problematic? What has happened to them? Have they been victimised? Until we have that kind of evidence base, it's very difficult to make institutional decisions about these things, and that's why at the moment we're treading, in our court, we tread carefully and leave it with individual judges in individual cases.
Yeah, beyond the hour. Please join with me in thanking both the Chief Justices for Thank you all for your attendance here this evening, and be well.